Welcome to this explainer. Today we're unpacking a really intense, high-stakes legal and medical journey that ended up producing a massive landmark decision by the South African Constitutional Court. We're looking at Hoffmann versus South African Airways. It's a dispute from back in the year 2000 that completely collided head-on with societal fears, medical realities, and the absolute fundamental right to human dignity.
So, picture this. Can an airline deny you a job just because of a medical diagnosis, even if you are perfectly, clinically fit to fly? That is the core question we're tackling today. Where exactly do we draw the line between a company's perceived safety rules, their commercial interests, and an individual's basic human rights?
Here's our roadmap for today. We'll start with Act 1, the dream and the denial. Explore South African Airways defense, dive right into the medical reality of HIV, examine the right to equality, and finally, look at the verdict through the uniquely South African lens of Ubuntu. Let's jump in.
Act 1. The Dream and the Denial. This is where we meet our central figure, Mr. Jacques-Charles Hoffmann, and his dream of becoming a cabin attendant.
Back in September 1996, Hoffmann applied for a position with South African Airways, or SAA for short, and he crushed it. He successfully navigated a really grueling 4-stage selection process. We're talking a pre-screening interview, psychometric tests, a formal interview, and a final role play. Out of 173 applicants, he was chosen as one of just 12 highly qualified candidates. 12. The only hurdle left was a completely routine pre-employment medical exam.
The medical examiner actually found Hoffmann to be clinically fit, perfectly suitable for employment. But then, the blood test results came back. The test showed he was HIV positive, and because of that one single result, his medical report was abruptly altered to just read HIV positive, and therefore unsuitable. Just like that, he was told he couldn't have the job. His dream was totally grounded before it even got to take off.
Which brings us to Act 2, South African Airways defense.
Why on earth did SAA think they were legally justified in pulling a job offer from someone who just proved they were incredibly capable? Well, they didn't just back down when Hoffmann took them to the High Court. They defended this blanket ban using a few specific arguments. First, they said flight crews need to be fit for worldwide duty, meaning traveling to countries where yellow fever is endemic and needing the yellow fever vaccine. SAA claimed HIV-positive folks might have severe adverse reactions to it. Second, they argued HIV-positive people are prone to opportunistic diseases which could, theoretically, be transmitted to passengers or leave the attendant too sick to handle an emergency. And finally, they brought up commercial perception. They basically said, look, if the public thinks we aren't promoting health and safety, our business will suffer, especially since their competitors had similar bans. And you know what? Initially, the High Court actually agreed with SAA. They bought into this idea that being HIV negative was an inherent requirement of the job. So Hoffmann lost round 1.
But he didn't give up. The case was appealed straight to the Constitutional Court of South Africa. And here, in Act 3, the medical reality of HIV, the objective science stepped in and completely flipped the script.
Because, you see, there was a glaring disconnect at the very heart of this case. SAA's policy assumed all HIV-positive people were an immediate, constant hazard. But the unanimous medical experts, and get this, even SAA's very own expert, confirmed that asymptomatic individuals function completely normally. HIV is progressive, right? So in its asymptomatic stage, the immune system isn't materially affected yet. The medical consensus was crystal clear. An asymptomatic person can do the work perfectly well, and any minimal hazards can be easily managed.
To put this into perspective, let's look at a very specific number. 350. That represents 350 CD4 plus cells per microliter of blood. Now, CD4 cells are those essential white blood cells that HIV attacks. Experts agree that getting the yellow fever vaccine only becomes a true medical risk if a person's CD4 count drops below this specific threshold of 350. Below 300, yes, a person is vulnerable. But Mr. Hoffmann? He was completely asymptomatic. He was nowhere near this danger zone. SAA was treating literally every HIV-positive person as if they were in the final immunosuppressed stages of AIDS, which was just factually and medically totally incorrect.
And honestly, this next part exposes a massive contradiction. The court pointed out a giant flaw in SAA's supposed safety argument. SAA was acting like this ultra-strict gatekeeper, rigorously excluding highly qualified HIV-positive applicants like Hoffmann. But at the same time, they were turning a completely blind eye to their own existing flight crew. They did absolutely zero HIV testing for current cabin attendants, meaning existing employees could contract the virus, continue to fly, and theoretically pose the exact same health hazards SAA was using to ban Hoffmann. You really can't claim a blanket ban is a life-or-death safety necessity while simultaneously ignoring those exact same potential risks in your own workforce.
With the actual medical facts on the table, we move into Act 4, the right to equality. This was a direct clash centered on Section 9 of the South African Bill of Rights.
The core question was this: does commercial interest justify discrimination? SEOA, which was a state organ bound by the Constitution, argued that public fear about HIV would hurt their bottom line. So the court had to decide if a company can use societal prejudice or competitive disadvantage as a legal shield to justify discriminatory hiring.
The Constitutional Court's answer? A resounding, absolute no. Justice Ngobo delivered an incredibly powerful, unanimous judgment. He stated quite plainly that fear and ignorance can never justify the denial to all people who are HIV positive of the fundamental right to be judged on their merits. He made it clear that bowing to public hysteria and stereotyping is a direct violation of constitutional dignity. Yes, legitimate commercial requirements matter, but prejudice? That can never justify unfair discrimination. Denying someone a job based on unfounded assumptions rather than their actual ability is just a blatant assault on human dignity.
Which brings us to our final chapter, Act 5, the verdict and Ubuntu.
To figure out the right remedy here, the court leaned really heavily on a moral and constitutional concept called Ubuntu. Ubuntu is essentially the recognition of human worth and deep respect for the dignity of every single person. The court emphasized that vulnerable, marginalized groups have to be treated with compassion and understanding. They explicitly said that people living with HIV must not be condemned to economic death just by being shut out of employment opportunities. The fix had to be just, equitable, and it had to strike right at the root of the discrimination.
So what did they actually do? Well, the Constitutional Court's final order was decisive. First, they completely set aside that earlier High Court ruling. Second, they formally declared SAA's refusal to employ Hoffmann unconstitutional. But the third step, this is the real game changer. They didn't just hand him a check for damages. The court gave him the fullest redress possible. They ordered SAA to physically offer Hoffmann instatement as a cabin attendant. They basically forced the airline to give him the job he rightfully earned, effective from the date of the order. Oh, and finally, SAA had to foot the bill for the hefty legal costs of the whole battle.
To wrap things up, I want to leave you with this thought to reflect on. How must the law protect the marginalized when public perception is clouded by prejudice? This landmark ruling in Hoffmann v. South African Airways forever changed employment law. It proved once and for all that objective science and the constitutional guarantee of human dignity must always, always overrule corporate fears and societal stigmas. Thank you so much for joining me for this explainer, and keep questioning how the laws around you shape the society we all live in.